Okay, so good evening, everyone. I'm glad you all could join us tonight. We have a very great webinar in store tonight about housing and income discrimination. And here to share the notable information on this topic is our speaker, Ryan Du Bois, Associate Human Rights Specialist at New York City Commission on Human Rights. He also has presented at our housing conference in 2019, and we're happy to have him with us tonight. So Ryan, you can start with your presentation if you would like.
Okay, great. Thank you so much for the introduction. Thank you so much to Palante for having me here tonight. And most importantly, thank everybody who's participating, to get this information. I appreciate you taking the time. And I definitely hope that this information will be valuable to you. Just letting folks know as well that, I'm going to be taking about a half an hour or so to speak and give information, but I really do want folks to feel free to ask questions if there's anything that you're not sure about or is not clear. I'm here to make whatever clarifications are necessary because, the information and the resources that we have is for you to take advantage of. And so please feel free to ask any questions or make any clarification that you may have. So without further ado, I'll go ahead and just speak a little bit about my agency. So again, my name is Ryan. And I'm an associate human rights specialist with the New York City Commission on Human Rights. In a nutshell, basically what that means is I do community outreach and education on behalf of the city's law enforcement agency for civil rights law enforcement agency, which is the Commission on Human Rights. So essentially what we do in a nutshell is if folks experience any type of discrimination, if you're discriminated against seeking housing in the place that you live, if you're wrongfully evicted, if you're discriminated against in employment, denied a job, treated unfairly in the place that you work, if you face a variety of different types of discrimination that may occur here in New York City in the 5 boroughs, then what we can do is provide free legal representation. So if you experience discrimination and you come and report it to us, and we can verify that in fact you were discriminated against and what took place was a violation of the law, then an attorney would represent you for free. It doesn't matter whether or not we end up accepting the case based on your complaint. It does not matter whether we win a case or not. It does not matter whether there is any type of cash settlement involved. If you were to win a settlement, never will we ever charge anything. Our attorneys are funded by New York City. Therefore, all of our services are always 100% completely free. So I think that's really the most important thing to clarify is that that service is available, a free legal representation. And that can look a variety of different ways. Sometimes folks pose the question of, well, maybe I feel that I've been discriminated against, but what can really happen if I make a complaint? Because we do understand that it can be a very long process, to take the time to contact us, follow through filing a claim. We may have to do an investigation into what happened. If we're lucky, there may be a quick settlement, but sometimes we may have to battle it out in court against, a landlord or employer or whoever else, and that can take sometimes many months. The thing is that it is worth it because there are so many concrete, tangible benefits that you can get from filing a complaint. If you are fired from a job, we can potentially get you that job back. If you were not comfortable working at that employer, we can potentially get you back pay for money that you were owed if you would have been working. If you were evicted from an apartment, we can potentially get you back into that apartment or a similar apartment. If you were denied housing, we can get you into that apartment that you were denied for. If you are being harassed, we can get that harassment to cease. We can get sometimes cash settlements for emotional damages, any type of additional expense you may have incurred. If as a result of being denied housing, you had to pay for a hotel or be eating out because you couldn't cook in your apartment for whatever reason, these are all expenses that we will also take into consideration in whatever settlement that may result for you. But first and foremost, always, we are looking at what type of discrimination occurred against this individual and how can we get justice for that person. In addition, what kind of measures can we implement to ensure that this type of discrimination does not continue to occur in the future against anyone else. And that's one of the most important parts as well. We try to take a restorative justice approach so that we're, again, first and foremost, we're always trying to look for justice for that individual. But furthermore, we also want to take it in consideration, what does justice look like in the long term? What kind of changes can we implement to ensure that this individual gets justice, but also the system is changing, the culture is changing, that we're sending a message to some of the most abusive and exploitative industries that practices that might have been commonplace before now must change. And so, you know, we have a wide variety of different mechanisms that we can implement to ensure that that occurs. So that's just a basic overview of the commission and what we do. You know, as I mentioned, myself, I am not an attorney. I'm with our Community Relations Bureau. So primarily what I do is community outreach and education. So my department, we're essentially the public face of the agency. So we understand that sometimes people try to access city services and it can be extremely frustrating. You might call, nobody might answer, you might not get a call back, you might have issues with a website if you're trying to, you know, file something through a website. And we don't want people to feel that they are getting ignored or lost in a bureaucracy or trying to, you know, contact some faceless agency. So for that reason, we, my department, are here to be the face of the agency, so that if you ever did have difficulty contacting an attorney or whatever service you were trying to seek, you can contact me directly. And I will, you know, my personal email will be displayed a little later in the presentation as well. So you can always say, oh, Commission on Human Rights, I remember I got that presentation from Ryan, or, you know, I was referred to Ryan from a friend of mine who saw the presentation, whatever the case may be. So you can always contact me directly or anyone else from my department, and we are in a position where we can assist you in filing a complaint. If you have filed a complaint and not received a response, we can help follow up internally to make sure you do get a response. So here on the screen, you will see, and honestly, this, I'm gonna go into a lot more detailed information throughout the presentation, but this is the most important thing right here. Now you know who we are, what we do. Unfortunately, you know, many people have not heard of the Commission on Human Rights before, but now you all know who we are, what we do. And you have our contact information right here. So my personal email you saw right there. As well, there's the phone number to contact our agency directly at the Law Enforcement Bureau to file a complaint. And you can also do that electronically through the website if you prefer to do that. So with that being said, because we are focusing specifically on housing tonight, and in particular on discrimination on the basis of source of income, I do want to move into that section. So another thing is that there's a lot of legal terms that the department uses, and those can sometimes be a little intimidating or ambiguous or confusing to people that are not familiar with those terms. So one term that I want to clarify is protected class. So protected class is something that I'm going to be referring to a lot throughout the presentation. Protected class very simply means a group that has been designated as protected against discrimination under the law. So you can probably imagine that discriminating against someone on the basis of their race is illegal in New York City. So race is something we would consider a protected class. Treating someone differently on the basis of the racial group or racial identity that that person belongs to, since that's illegal, race would be considered a protected class. So the same thing goes for other things that you might think of. Sexual orientation. It's illegal to discriminate against someone on the basis of their sexual orientation. Therefore, sexual orientation is something we would call protected class. Disability, protected class. Religion, protected class. So when I say that, that's what that's referring to. Those groups, those identities, those categories designated as protected. So with that said, I'm now going to move into the list of protected classes that exist in the context of housing and the various protections around those groups, because this is essentially the foundation of the law. So number one that we'll look at is age. So a person cannot be denied housing or treated differently at all in their housing on the basis of their age, whether that be on the basis of them being young or elderly. The presence of children, this is an extremely important one because unfortunately, we know that this is a very frequent form of discrimination that people experience. So they may be told, units are available. We have this available, we have that available, da, da, da. The person reveals that they have children that would be moving in with them, and then suddenly the landlord decides, oh, actually these units are not available, or they would have been available if it was just you, but now that I know that you're, X number of people will be moving in, it's no longer available. That is illegal and discriminatory. Presence of children is a protected class under the law, which means that as long as the number of people that would be in the apartment would not be violating like a fire code or a safety code, that you have the right to apply to and be eligible for and live in any apartment of your choice, including if you would have children living with you. So race and color, as I mentioned, those are both protected classes as well. You cannot be profiled and discriminated against, denied housing, given inferior housing, harassed, etc., on the basis of your race or color. And we make that distinction as well because there may be instances where someone from a particular racial group discriminates against someone of a different racial group, but there may also be discrimination of people within the same racial group on the basis of skin tone or color. So we also make that distinction within the law. Disability. So there are many different types of discrimination on the basis of disability that may occur. That may be being denied housing because the landlord may consider it an inconvenience. That may be if the person does not have accessibility to their housing, free and independent access. So if the person uses a wheelchair, the landlord would have the obligation to install a ramp, whether outside or inside the building. If an individual would require grab bars to be installed, maybe in their bathroom or kitchen, the landlord would have the obligation to do that. Any type of accommodation that a person may require on the basis of having a disability, the landlord must provide and must pay for. Sometimes the landlord also tries to get the tenant to pay for it, but that would also be a violation of the law. So gender and gender identity, as well as I mentioned, any type of profiling, discrimination, harassment on the basis of gender or gender identity or sexual orientation would be illegal as well. Immigration or citizenship status. Unfortunately, we also know that landlords will take advantage of people on the basis that they may either know or suspect that person may be an immigrant or may have a particular documentation status. That information is none of the landlord's business. And if the landlord were to become privy to that information for whatever reason, they cannot discriminate on that basis. They cannot treat certain people worse because they are immigrants or because they have a certain documentation status. Undocumented people also have the right to safe and accessible housing. Landlords cannot threaten someone with deportation. They cannot threaten to collaborate with any type of law enforcement to extort or mistreat tenants in any way. So that's another really, unfortunately, we know a common method of discrimination that landlords employ, but it is illegal. And we do encourage people to file complaints if they have experienced this. And I'll also mention that many people are sometimes hesitant to file complaints with us because of retaliation that they know may occur. But we do have specific protections as well for individuals who experience retaliation. And we take that into consideration. And any landlord that did engage in retaliation on the basis of you filing a complaint would experience harsher penalties under the law. Lawful occupations, so this refers to what your profession or job may be. This was really largely created specifically because certain people with certain jobs, such as lawyers, were being discriminated against because landlords considered them potentially troublesome if they were in their buildings. So based on the work that you do, your profession or occupation, you cannot be denied housing either. Marital or partnership status should not matter whether you're single or married. National origin, I also spoke about that before. National origin and immigration and citizenship status are all protected. Status as a victim of domestic violence or sexual violence or stalking. This is an important one as well because landlords may consider someone who may be a victim of domestic violence to be a potential liability for their building, but this is an extremely abusive and discriminatory attitude. An individual cannot be denied housing or evicted from housing on the basis that they are a victim of domestic violence or stalking. And in addition, they would actually be entitled to accommodations to accommodate that person's safety if they were in that type of situation. Pregnancy as well. An individual cannot be denied housing or treated differently in their housing, or encouraged to leave from their housing or harassed in any other way on the basis of being pregnant. Religion, I also mentioned as well as protected class here, and in addition, uniformed service or military status. So we also know that unfortunately, many landlords hold certain stereotypes about the potential mental health of somebody who may be or may have served in the armed forces, and there is discrimination against people who are veterans or active armed service members, but that's also illegal. Of course, we know that veterans and armed service members have equal rights to choose and live in the housing of their choice as well. So that's an overview of the protected classes that we have. The one that I omitted, because I want to spend the most time zeroing in on, is lawful source of income. So lawful source of income as a protected class essentially boils down to one simple thing, which is you can pay rent with whatever income you choose, as long as that income comes from a legal source. So that could be the income that you earn at work. That could be the income from a public benefit, such as a Section 8 voucher or city FEPS, HASA, benefits associated, as I mentioned, with uniformed service members, GI Bill type benefits, any type of voucher or public benefit that an individual may choose to use to pay the rent. That individual has the right to view, apply to, live in, and enjoy safely as any other person using any other source of income in New York City. It is not limited by neighborhood, by type of housing, by income. An individual, again, no matter what the source of income they use, they have equal right to live in any apartment that they want to in New York City. So what does source of income discrimination look like? It can look a variety of different ways. Number one, if you ever see advertisement for housing that says no vouchers accepted, illegal. Right off the bat, you will know that that is illegal because that language is never permitted on an application. If it says no vouchers accepted, or if it says, if the landlord says we accept certain vouchers or programs, but not others, that's also illegal. They cannot pick and choose which they choose to accept or not. If the landlord were to say, we'll accept any program, but not for this building. If they were to say, well, maybe, this building is not the best fit for you. What about this other building on another block or in another neighborhood? That's called steering, and that's also illegal. That's essentially, a primary method of contemporary segregation. And that's definitely illegal as well. The landlord cannot discourage you from living in the building or neighborhood of your choice. They must accept your application for the housing of interest to you. If you were to have your housing and the landlord were to limit your access to facilities in the building, if the landlord were to say, okay, you can live in this building using your voucher, but you cannot use the gym, you cannot use the lounge, you have to enter and exit through a different door. Those are all forms of source of income discrimination as well, because you have your housing, but you're being denied equality in your housing. You're being denied equal treatment and access to the facilities of the building. And that's a form of source of income discrimination as well. Let's say a new landlord was to take over the building and decide that they no longer wanted the tenants who had that were paying rent with vouchers. So they decided not to renew the lease or any other paperwork for those tenants. That would also be illegal. They're discriminating against you and attempting to remove you from your housing on the basis of your method of paying rent, which is perfectly legal. So that would also be a violation of the civil rights law. So these are some of the primary examples. Any type of harassment, if any agent of the landlord super, any maintenance worker, anyone else in the building, if they were to be engaging in any hostile behavior, and other forms of tenant harassment, construction as a form of harassment, any type of harassment that landlords might employ, if they are employing those methods specifically to target particular tenants that are that have a certain source of income that they're using to pay their rent, this would also be considered a violation of this part of the law as well. So these are the primary examples of source of income discrimination that, again, we unfortunately do know occur, and unfortunately are still relatively common practices. Many individuals, like I said, have not really been familiar with the Commission on Human Rights and are not familiar with the degree of protections that they actually do enjoy under the law. And also, we know that it can be difficult if an individual is in the middle of their housing search to be constantly, keeping a list of who the landlords are that have, committed this type of discrimination, and follow up and make a complaint about each one. We definitely understand that searching for housing is not easy in New York City. It can be a very stressful, very long process. So again, I say all this to just reiterate that while it can be stressful and difficult to go through the search in the first place, and on top of that, be simultaneously dealing with, civil rights lawsuits and complaints, I can only stress again the very real, tangible, concrete benefits that filing a complaint can bring you. I've had situations where I've given a presentation just like this, and somebody has come to me immediately afterwards and said, I experienced this, over the course of the past week. I was in touch with the landlord. They said they had, a dozen units available. I was excited to move in. I revealed that I was going to be using a voucher. They suddenly, said that nothing was available or stopped responding. And I've seen individuals the same day we've gotten an attorney to contact the landlord, and they've been approved to move into the housing the same day. Now, I would not be so naive to say that that happens all the time, but this is an example of the fact that, our agency, we are here to serve the public, and we are a law enforcement agency. And certain cases are easier or more difficult than others, but we have successfully represented so many individuals that have experienced this issue. In fact, in our law enforcement bureau, we specifically have a team called the Source of Income Unit that focuses specifically on these issues. Typically, when we receive a legal complaint, it has to go through a lengthy review process, but because of the activities of the Source of Income Unit, they actually do emergency response work, where they can, do a much quicker turnaround if they were to get a referral about a particularly urgent situation, such as the case that I previously mentioned. So with that said, I'll also just kind of, again, walk through something which I think is probably one of the most important things, which is actually filing a complaint. So I just want to speak a little bit about what that looks like so folks are clear. So there are multiple ways to file a complaint. Number one is to call the number that was up on the screen, which is 212-416-0197. Again, I'll repeat that, 212-416-0197. So here we have it again. So this is called the info line. The info line is the team within our law enforcement bureau which receives complaints. So if you were to call this number, essentially that would take you directly to the info line, and you would state exactly what happened, state that you believe you were discriminated against, state your name, contact information, etc. Now, again, because of the volume of complaints that we receive, it is likely that someone may not actually answer the phone, that you may have to leave a voicemail. That does not mean that your complaint was not registered. If someone does not answer the phone and you're instructed to leave a voicemail, all that means is that you'll leave the voicemail, and that when the individual becomes available, they will go through the voicemails, collect the information, and someone will contact you. So I always say that because people feel that because they got the voicemail, their call didn't go through. It did go through. You just have to leave the same information you would have told the person, and they will follow up with you later. again, if time were to go by and no one followed up with you, or if the situation was particularly urgent and you needed a quicker turnaround, that's when I come in. So you also see my email here. You can always feel free to reach out to me directly to help expedite the process of your case. The alternative method to calling this number is also visiting the website. So we have that here in English and Spanish, nyc.gov/human-rights or Derechos Humanos. So from the main page of the website, there's a lot of information on the website, but there's one tab that you will see that says report discrimination. And also, by the way, if you were to access the website on its English language page and wanted to access it in any other language, you can just go to the top right corner and choose translation into the language of your choice. So there will be a tab right on the main page that says report discrimination. You click on that, it'll take you to an online form where you can put all the detail, everything you would have said over the phone, you can write down on the page, click submit. And some people prefer that because then you have an electronic verification of the fact that you submitted a complaint and you have that documentation. So that's the process of filing a complaint. Since I said the word documentation, that also reminds me, you do not have to have any evidence or documents in order to file a complaint. All you need is the suspicion or the knowledge that you were discriminated against, and that's enough to file a complaint. Now, that being said, to the extent that you can acquire documentation which proves the discrimination that you experienced, that will strengthen your case. That will make it more likely that an attorney will accept your case, because an attorney can only accept your case and represent you if they feel that there's sufficient evidence to prove in a court of law before a judge that you were discriminated against. So to the extent that you can get documentation to prove what you have experienced, that will help you and that is encouraged. We know that some landlords are very slick, they're very savvy, they're very aware of the law, and they take very strong care to not get caught. But we also know that some landlords, they put these things in writing. I've seen plenty of cases where a person receives a text or an email that says, we don't accept vouchers, or everything was going fine. There was a long conversation in writing, perhaps in text, and then the person revealed that they were using a voucher, and then the conversation stops. That's basically equivalent of the landlord saying we don't accept vouchers. So to the extent that conversations can be put in writing, to the extent that you can record phone calls or conversations, New York is what we call a one-party state, meaning that I can record a conversation I'm having with someone else, and even if they don't know I'm recording, I can still use that in evidence in court. I don't need their consent to record. So if I'm having a conversation, if I'm in the landlord's or the management company's office, I can be recording, let's say on my phone in my pocket, and not tell them and leave the office and submit that as evidence in court. So to the extent that you can have things in writing, to the extent that you can have things recorded, to the extent that you can document conditions in your unit or in your building, all these things are very helpful. So I've said a lot. It's been about 30 minutes, I think. I know it's a lot of information, so I want to stop here. I know we're going to have time for a little question and answer. So I just want to give folks the opportunity to ask questions and make clarifications. So I'll stop there and see what folks have to say.
Okay, yeah, we do have some questions in the Q&A. Robert, can you?
Sure. Yeah, we do have a couple. One of the first ones that came in. What about dog, cat as emotional care? Is there isn't there real estate that's being sued for SOID?
Right. So I'm not sure what SOID is referring to. I mean, SOI, I assume a source of income. I'm not sure what the D is referring to. But with regard to the question of service animals, emotional support animals, yes, absolutely. So as I mentioned, disability is a protected class. we define disability as broadly as possible. So disability does not necessarily mean that you have to have a visible physical disability. Disability can be physical, it can be visible or invisible, because there can also be a physical disability that I might not be able to observe with my eye, but it can still be present internally, physically. Any mental, psychological, emotional, impairment, or whatever word you may use, would be considered a disability, or a history of record of such a disability as well. That's an important one too. So although you may not have any recent medical documentation stating that you have been certified as having a disability lately, if there's ever been medical documentation of you having a disability, that's also sufficient for you to justify requesting accommodation. And that includes emotional support animals. So a building does have the right to have a no pets policy. However, as a person with a disability, you have the right to an exception to that policy for your service animal, because it's a no pets policy. It's not a no animals policy. You can still have a service animal or an emotional support animal on the basis of that being an accommodation on the basis of a disability. So if the landlord were to deny your right to have a service animal, that would constitute discrimination as well. And that would be illegal.
So another question that we have, and please do take advantage. This is a fantastic topic, and so we have our chat open, Q&A open. So anything that comes to mind that you want to have read out loud and answered. Another question that came in: do I have to get a lawyer or an attorney when faced with housing discrimination?
So do I have to get an attorney? Well, I'm going to speak just on behalf of my agency, because I'm sure there's multiple methods that a person could undertake to combat discrimination, some of which maybe they can represent themselves pro se. But just speaking on behalf of my agency, that's what we do. We offer free legal representation. So if you were to come to the Commission on Human Rights, presumably it would be because you were seeking representation. As I mentioned, as a city agency, all of our attorneys are employed directly by the city. As a result of that, they're paid by the city and they do not charge you anything. That's why our services are free. So assuming, right, again, that your case was jurisdictional under our law, that we accepted your case as a result, we would have attorney represent you. And I'll also say, by the way, that our attorneys are like breaking record numbers of settlements that we have, even within the past year of pandemic and remote working. There was no interruption in service. So we quite seamlessly actually transitioned from in-person to remote work, including the attorneys. So there was no gap in service. Our attorneys have continued to represent clients remotely. And last year, we actually had the highest number of settlements ever. So our attorneys are still very active representing individuals. So yeah, that is our primary service.
Just to kind of follow up on what you would need. So do you, to prove discrimination, I mean, how much do you need to present, or what specific, beyond what you mentioned so far, would you need as far as evidence or proof, beyond what you were mentioning?
Right. So as I mentioned, you don't need anything technically to file a complaint. All you need is your lived experience and your belief that you experienced discrimination. That is all you need to file a complaint. Now, with regard to what you need to win a case, that honestly can look a variety of different ways. So as I mentioned, to the extent that an individual can get documentation, that's great. So again, that may be text messages, that may be email chains, that may be recorded conversations, that may be photos of videos of your living conditions, that may be testimonies of other tenants, or even agents of the landlord if they were willing to support your complaint. However, the reason that I say that you really don't need anything is because we also have our own investigative methods. So as a law enforcement agency, we can initiate investigations, which means that, let's say you and other tenants from the building, and I'll also say this, there's also power in numbers. So one tenant complaining about a particular issue is different from 15 tenants from the same building, or perhaps, you know, the same landlord with different buildings coming together and filing a complaint together because their testimonies will support each other. So let's say there's an instance like that, right, where we have multiple tenants coming forth and not a single tenant has any hard evidence, but they all have testimony that they're experiencing similar discrimination. We can subpoena documents, meaning that we can force the landlord to hand over to a judge internal documents, emails, financial records, etc. One of our, I think, most interesting and effective investigation methods as well is what we call testers. So tester is basically like an undercover agent. So if we have folks coming to us saying that this particular landlord is, for example, just sticking with the example of lawful source of income. Let's say we have multiple people that are coming to us saying, the landlord, I tried to apply to housing. The landlord said that, you know, a dozen units were available. I said I was going to use a voucher. All of a sudden, no units were available anymore. We can actually have employees of the commission, testers, basically be undercover, posing as housing applicants to apply to the housing, go through the process and see what their experience is like. And if one of our testers has the same experience where they apply to housing, the landlord offers them housing, they reveal their, for example, have a Section 8 voucher, the offer is withdrawn, then essentially we have caught them red-handed. We have documented one of our own commission employee testers experienced that discrimination. And so even though no one who complained had any evidence, on the basis of those tips and those complaints, we initiated the investigation and, you know, built the case like that. So there's so that's why I say, you know, to the extent that you can get documentation, definitely do it. But even if there's none, still complain, because you never know what we may be able to uncover just through our own investigation.
All right, so we have another one actually that just came up. What about asking if you're employed or about your credit score?
Yeah, so the landlord in most cases is allowed to ask about your credit score and your employment situation. The exception to that would be if you have a voucher that's paying 100% of your cost of living, so your rent and utilities. Then you would be exempt from a credit score, because the point of the credit score is for the landlord to ensure that you will be able to pay your rent. So if you have a voucher or program that is paying 100% of your rent and utilities, then your credit score is no longer relevant because the money is coming from the voucher. So that would be the only case in which you would have an exemption and the landlord would not be allowed to run a credit score on you.
I have a question. Is there like a separate process for, like, if you're experiencing income over housing, like is it a different approach for each one, or is it like the same thing?
Yeah, I mean, that's a good question. I think I honestly, I would say that every single case is different. It's very difficult. Like, for example, sometimes folks will come to me and give like a very specific example of discrimination that they may have occurred, or like a hypothetical scenario. And it's very difficult in many instances to say this definitely is or this definitely is not discrimination, because we often have to take into account so many particular factors. And you know, again, we do have to do a thorough investigation as well to ensure that in the first place, the complaint is jurisdictional, meaning that the alleged discrimination does violate the law, and then also that there's sufficient evidence to actually fight the claim. So every single case is different. I mean, of course, there's certain things that, again, I will say, like, you can say basically with 100% confidence are discrimination. Like if an application says no vouchers accepted, that's pretty clean cut. That's very cut and dry. That's discriminatory. But when it comes to various, situations that an individual may find themselves in, unfortunately, with the law, there's a lot of gray area as well with regard to enforcement. And that can be frustrating because sometimes there are cases that we want to accept and represent people, but just because of the limitations of the law, there's just certain cases that are more difficult to move forward with than others. So every single case that we get, we do a very thorough assessment of that individual situation. And of course, that includes speaking at length with the individual to make sure that we've heard their full story. And I'll also say too that we also know that people might be discriminated against for multiple reasons at the same time. It's not always this person was discriminated against on race, this person because of their disability, this person because of their source of income. People have multiple identities, and those can complicate the situation. This is the framework of intersectionality. We understand that a person's identity or the context in which, right, their socioeconomic context, many factors can combine in a situation of discrimination, and we're taking into account all of those factors. So was it a combination of your source of income and racial identity? Was it a combination of the person's disability and sexual orientation? Was it a combination of the fact that the person has presence of children and is a victim of domestic abuse? We're going to be taking all of that into consideration, and the person is not limited to one single complaint. If the person wants to complain that they were discriminated against for 4 different reasons, they have the right to do that, and our investigation will take that into consideration. So every single case is different, and we do a thorough investigation.
I think we had the person who asked a while back about the pets. I think she didn't get a chance to hear it. If you wouldn't mind revisiting that briefly, that regarding pets as emotional support and lawsuit out. Sorry, I'll read that a little more slowly for the interpreter. My apologies. Regarding pets as emotional support and lawsuit out on a company for SOID.
Yeah. So again, I would have to have the person clarify what they mean by SOID.
Sure.
I mean, SOI, source of income, if that's what we refer to it. I'm assuming that the person may be referring to the same thing, but I don't know what the D would mean.
Sure, we can.
Got you. Okay, source of income discrimination. Yes. So with regard to service animals, let's take that first. So essentially, a person has a right to have service animals or emotional support animals, regardless of the building's pet policy. So because service animals are not pets. So a landlord does have the right to have a no pets policy, but they cannot have a no animals policy, meaning that a service animal is not a pet. Therefore, a person who would require a service animal or an emotional support animal, which would be considered on the basis of disability, that would be the protected class. Again, a person must be provided with accommodations on the basis of having a disability. So we define disability as broadly as possible to include any type of physical disability, whether it be visible or not visible, any type of psychological, mental, or emotional impairment, or a history of record of such an impairment. So if a person is in such a situation, then they would be entitled to an accommodation on the basis of a disability and would have the right to have an emotional support, or a service animal. And what was the question with regard to source of income discrimination?
The question, original question was, what about dog or cat as emotional care?
Mm-hmm.
Isn't there a real estate that's being sued for source of income discrimination? And then she followed up.
Okay.
About that.
Yeah. Our source of income unit is real busy, unfortunately. Like I said, this is definitely one of the most frequent types of discrimination that occurs in the city, and it's definitely one of the highest number of complaints that we receive. So our source of income unit is constantly suing landlords. And actually, I'll also say, not always suing them. If they can do it, if it's quicker to do a direct intervention and to just call the landlord and threaten them with a lawsuit, that often is sufficient to get the landlord to just turn around and give the apartment. So constantly suing them or doing interventions. But yeah, landlords are getting sued for this all the time.
Another question that just popped in. If your income is flexible and you do not get W-2 and a regular check, how can they not discriminate against you?
Yeah, so if you, for whatever reason, if you had a non-traditional employment situation, that you had alternative documentation to show your income as opposed to what the majority of people may use to show their income, the landlord would be encouraged or required to view the documentation that you can show, to show, again, your source of income and your eligibility for the apartment. Again, it's tricky to say without further details. I would interpret the situation to say that if the landlord was not accommodating you by viewing whatever documentation you were using to show your income, that could be considered lawful source of income discrimination. I'll also say that this is sometimes an issue, particularly for undocumented individuals who may not have certain government issued documents to show their income and may use alternative documentation, whatever that may look like. And in that case, if the landlord was to not accept that documentation and deny the person the opportunity to apply, that could be considered lawful source of income discrimination, in addition to documentation on the basis of immigration status or national origin.
I think there was just a continuation to that original question regarding AC walkthrough unit that was in the apartment when we moved in, but now the landlord does not want to replace them at the end of their life, nor reduce the rent for reduction of service. Is this discriminatory?
So there are many types of tenant harassment that occur. Whether or not it is within the jurisdiction of the Commission on Human Rights depends on the question of why is it occurring. So let's use this particular example of not replacing AC units. If this is a policy that the landlord employs across the building and everyone in the building is subject to this policy, it may be a form of tenant harassment or a violation of housing law. I'm not familiar with this area of the law. That's why I'm saying maybe. But in this particular instance, everyone in the building would be experiencing it. The landlord is not necessarily targeting particular individuals. Now, if the landlord was replacing AC units for certain tenants and not for others, and it became clear that there was a pattern about who was receiving the preferential treatment and the neglect, for example, if sticking with the example of lawful source of income, if everyone with a Section 8 voucher, the landlord was not replacing their AC units, everyone else in the building he was, that would be considered an example of lawful source of income discrimination, because there's that deferential treatment. And it could be anything. If it was all the tenants who were of a certain racial group, all the tenants who were immigrants, all the tenants who had disabilities or who were elderly. So the question is, why is it occurring? If there is a pattern that suggests discrimination on the basis of a protected class, then yes, it would constitute discrimination. But if it's a policy that's just a bad policy that's affecting everyone, it may be illegal, but not necessarily a violation of the human rights law.
Is there a tenant's rights brochure from your office?
Yes. So that's where our website comes in. I would really encourage folks who are interested in additional information to visit our website. There's a lot of information on there. There's like a plethora of brochures and flyers, press releases. We issue annual reports that have detailed information on all of our cases, how many cases we've won, what the nature of most of our complaints are, what settlements look like. You can view certain settlements from cases that we've represented people. Yeah, you follow us on social media, see what, community events we have going on. So there's so much information on the website, including, of course, information with regard to our housing protections. There's fact sheets and brochures on that as well. So I definitely encourage folks to go on there and familiarize yourself with the literature. Because again, I'm only speaking in this presentation about housing protections in general and source of income in particular, but the law is so wide and so vast, and there's so many protections that people just don't know about. Some things people intuitively know, of course, that's illegal, but there's so many protections under the law that folks are not even aware of, that they might even be surprised to know that are illegal, even though they might have been experiencing that mistreatment. So definitely encourage folks to visit the website and familiarize yourselves with the literature if you're interested.
Great. So that kind of wraps up the first round of questions, or I don't know if you wanted to continue on with other topics or, to see, but we don't have additional questions at this moment.
Yeah, I mean, I'll defer to you. I certainly, I'm happy to answer any questions that there are. I also know that it's a Friday evening, and so I want to respect folks' time as well. So I'm happy to speak to any other topics that may be of interest to folks. But I'll defer to the host's judgment.
Jakari.
I mean, if you have anything else you want to add, you can. I mean, if you feel like you want to.
Yeah. I mean, I'll just give a quick recap, I guess, of other areas of the law where we have protections, since I was just kind of alluding to that. So, we do have protections in employment again as well. That can look so many different ways. If folks are denied jobs, if folks are experiencing any type of mistreatment within their place of employment, sexual harassment, being paid less for the same work, undocumented people being paid less, women being paid less than male counterparts, any type of discrimination. Disability accommodations are also relevant in employment as well. Being wrongfully fired on a discriminatory basis, all these things are protections as well. Discriminatory harassment is a really important part of our law. So, this has been particularly highlighted in light of the unfortunate rise in anti-Asian bias and attacks due to, stereotypes and scapegoating and xenophobia associated with the coronavirus pandemic. So, any type of intimidation, of course, any type of violent attack, any type of threatening, any type of interference with your safety or enjoyment of your constitutional rights. This would all be considered discriminatory harassment, and that's also illegal and can be reported as well. Another area is public accommodations. So that's the legal term to refer to any place that just offers goods and services to the general public. So that may be a place of business, a private business such as a restaurant, a bodega, movie theater, or that may be like a government-run hospital, school, public transportation. So any place that offers services to the general public, they would not have the right to deny you service, to make you feel unwelcome, to give you inferior service, to target you in any way. The discriminatory treatment in where a restaurant might seat certain people, or certain people being followed around stores on suspicion of stealing, or any type of mistreatment like this. We know in the medical field, people being given inferior treatment by doctors and nurses. All these things are violations of the law as well. And I say this because I hear so many stories of folks who have experienced this type of mistreatment, but they don't complain for whatever reason. Maybe they feel that it's not likely anything would come of it, or they're willing to just shrug it off and don't want to dwell on it, or whatever the case may be. But I always just really finish with encouraging folks to complain, because real change comes when people file complaints. Real change comes. We've seen instances where a company has changed the whole way it does business. We've seen companies retrain their employees, hire, diversity and inclusion staff, have all of their top level staff undergo our human rights law trainings. We've seen companies issue scholarships for students from underprivileged backgrounds to enter their industry. And of course, for the individual, we've seen them get cash settlements, emotional damages, and just a sense of justice, just a sense of justice of knowing that the wrongful treatment that they experienced was recognized and remedied. So there are just so many different types of benefits that can come for you as an individual and, the city as a whole when people do take that step and take that initiative to file that complaint. And we know it's not an easy process. We know that it can be very stressful and very daunting, but we need people to step forward in order for us to be able to initiate that change and take action as well. So I'm just gonna finish by saying that, by just really encouraging folks to, please file complaints. If hopefully you will not, but if you ever do, experience this type of treatment and would require our services, and again, always feel free to reach out to me as well. My email was shared here. As I mentioned, I'm here to serve you. I'm here as a public servant, a civil servant, a representative of my agency to serve you. So please never hesitate to reach out to me directly with any questions or concerns, and I'll be happy to assist in any way that I can.
Yes, thank you, Ryan, for joining us tonight and shedding light on such a very important topic. Sometimes, we experience discrimination and we don't report it, but it's imperative that we do report and that we hold like the landlords accountable or whoever accountable for their actions so the cycle won't continue. So please contact New York City Commission on Human Rights. And Ryan, if you could say the number again, just.
Yeah, absolutely. The number is 212-416-0197.
Okay. Yeah, so make sure you call them or you can call Palante and we can assist you as well. Yeah, so this comes to the end of our webinar tonight. Thank you, Ryan, again. Thank you, Robert, our Zoom tech, and thank you, Daniel, for translating for our Spanish viewers tonight, like he always does. We're gonna just pull up a quick poll tonight just to see, our attendees view of tonight's webinar. So y'all can vote really quickly. But other than that, everybody enjoy their weekend and have a great Memorial Day.